Well, welcome to the latest of a series of conversations convened by the Centre for Competition Policy at the University of East Anglia. I'm Tom Sharp, I'm a lawyer, and I chair the Centre's advisory board. It's a real pleasure to invite our conversationalists today, and in particular, Carl Shapiro from Berkeley, the Haas School of Business. Carl genuinely does not need any lengthy introduction from me, so I'm not going to provide it, but he has been an important intellectual force in the construction of merger guidelines. And as we'll hear, we'll offer a critical analysis of the developments which are taking place at the moment, which are rather important in the Biden administration. I can think of nobody better qualified to talk about it today. But on this side of the Atlantic, we also have Professor Amelia Fletcher, who is a professor at East Anglia in the Centre, and she'll join the discussion dealing with, I guess, the UK perspective. She too brings some high-level policy experience and is currently a board member, the senior independent director, actually, of the Competition and Markets Authority. I think I'm obliged to say you're speaking in a personal capacity today rather than binding the CMA, so I've said it for you. And then Dr. Elias Deutscher of the Centre, a lawyer, I'm pleased to say, formerly of the European University Institute. Now Elias has done a lot of work on the European merger scene, is a critical friend of the General Court, which has come down with some eccentric judgments, in particular CK Telecom, which we'll spend a bit of time on later. And he'll be bringing an EU perspective to our conversation. So Carl, without further ado, why don't you kick off and tell us a little bit of what's happening in the Biden administration and maybe why they've got it wrong.
Well, thank you for inviting me. It's a pleasure to be here. I should just say where I'm coming at this in terms of looking and watching the Biden administration is somebody who was in the Obama administration as a chief economist in the Justice Department at the beginning there and involved in the merger guidelines heavily, but also served in the Clinton administration in the same role. So been doing this for many years. And what's striking, and you probably heard this at least in the newspapers, is we're really in a very different world for antitrust than I've seen in my 40 years doing this as an academic practitioner and government official. The neo-Brandeisians, as they're often called, are in charge. And I mean, the whole administration, it's clear, you should be clear, I would like to emphasize, the President Biden issued an executive order last July, which I very much like, committing sort of a so-called whole of government approach to competition policy, not just antitrust enforcement, but throughout the federal government, which some of us have been pushing for a while. And in part of that, some very strong rhetoric from the White House about declining competition in the American economy and the need to reverse that and the failure of antitrust. Now, I don't agree with that characterization. They go too far, but this is coming from the top. Let's put it that way. There's also a lot of support in Congress, mostly Democrats, but not entirely Democrats, for being more vigorous with antitrust. Partly that is for weird reasons having to do with antipathy to the big tech companies, but it's there. So we're in a very different political environment than I've seen before. Compare that to what we experienced. Christine Varney was the Assistant Attorney General who brought me in as her chief economist in 2009. That was the Great Recession. There was a lot of concerns. Don't be too tough on business. It'll hurt the economy. Now we've got, it's wide open in terms of the White House, considerable congressional support for doing much more with antitrust. So it's a great moment for antitrust to do more. And I certainly believe in the United States, antitrust has not been strong enough for the last 40 years. I mostly attribute it to the courts and the way the courts have moved. And I'll come back to that in just a moment. So this is really, who are the neo-Brandeisians? What do they want? It's really a populist movement, and it's more about political economy and very much not really so much about the economics. So we can talk more about this as we go, Tom, but I think Lena Khan, especially with some very strong writings as a law student, in that vein of we need, basically the goal is to deconcentrate the economy. So you really don't want to have large firms because they're politically powerful, and that is a threat to democracy. If I had to summarize it, and it's not about what many of us have been doing for decades, which is trying to understand economic effects of a merger or a business or a practice for antitrust and draw boundary lines. This practice is good for consumers or good for competition. This practice is not. It's much more, we have to rein in big firms, break them up, not let them merge for political reasons. Okay, so the context for that is, so their reading is that we've had a failure of antitrust for 40 years, an abysmal failure, a huge increase in concentration and monopolies throughout the economy, and we need to fix it. I don't agree with that characterization, just as a matter of the evidence. I think that's a false narrative. I think there are problems, but I think it's an extreme and an inaccurate picture that's been painted. But you can see why people would want to do that in order to then dramatically change policy, because you have to say the policy we've been doing for years has so totally failed, we need something dramatic. That's the narrative, that's the story. The problem for them, and I'm sure we'll come back to this if we want to explore more with what's likely to happen next in the United States, is the judiciary. Okay, the Justice Department, all they can do is go to court, and it's a law enforcement agency. The FTC has some additional powers. They can write rules and things. So there's quite a difference in many respects between the DOJ and the FTC. In a number of respects, but ultimately they all have to go to court, and companies are well counseled now, will fight back, and there's a lot of case law that is going to be a problem. So what you see Lena Khan doing especially is skipping past most of the case law for the last 40 years and going back to 1960s Supreme Court decisions or invoking congressional intent in 1890, okay, or 1914, when the Sherman Act and the Clayton Act and the FTC Act were passed. So that's going to be very interesting to see how that plays out when they actually go to court and run into a judiciary that's been hostile to antitrust for decades.
Yeah, well, thank you for that. I'm just turning to Amelia. I mean, what do you recognize in that tradition in the UK and perhaps in Europe as well?
So thanks. I thought I'd give a bit of background to kind of my experience here and kind of what's been happening in the UK. I was actually in 2009-10 at the same time as Carl was at the Justice Department and Joe Farrell was at the FTC, and they were both basically revisiting the US horizontal merger guidelines. I was at that time chief economist and senior director of mergers at the Office of Fair Trading, which is the body that preceded the Competition and Markets Authority. And I hatched a plan with Alison Oldale, who was chief economist at the Competition Commission, our sister body, that we should rewrite the joint OFT-CC merger assessment guidelines over here as well. I think guidelines are really interesting in that they tend to involve a mix of two things. One is setting out how practice has simply changed over recent years, and that's clearly very useful. But I think the second is that they quite often used to try and set a direction of travel for the future, for future analysis in a slightly heroic way, because you're just hoping that the courts are going to stick with what you say. But actually courts, at least in the EU and the UK, have shown a degree of deference to guidelines. So they can be quite powerful forces for change. Now, back in 2009, the key thing that we wanted to change was to introduce a more economic approach to the assessment of unilateral effects mergers, but in doing so, emphasize the value of really simple empirical techniques like Carl and Joe's own Guppy measure. I won't go into what the Guppy is, but it's a very simple measure of whether a merger is likely to have an anti-competitive effect. And so we really were wanting to push the use of that and similar techniques in the UK, and more generally dial down the reliance and importance of market definition in mergers and dial up the arguments around merger analysis really being about the delta, the change in competitive constraints arising from the merger. So that was our big thing that we were trying to get over at that point. And I'm pleased to say that I think those guidelines were really very successful in reshaping merger assessment, at least in the UK. They were successful in the EU, strangely, as well, at least until the recent Hutchinson merger, which Elias will talk about later. I would also note that, however, and Carl mentioned that you can't paint the picture around changes in concentration necessarily that the neo-Brandeisians would like to. I'll just say a little bit about what's happened in the UK. The UK, like the US, had fairly consistent growth in market concentration from the late 90s through to 2010. Interestingly, and obviously I cannot draw any correlation, since we published our revised merger guidelines, concentration has fallen back fairly dramatically in the UK, albeit not to 1990s levels as yet. So I really don't think I can pin that all on the merger guidelines, but it is true that they did signal, I think, a clear intention to take merger review more seriously. So then we end up in 2019. So mergers review's been working well with those guidelines, but by 2019, we've got this big new issue of the dramatic growth of a small number of enormous digital platforms with huge and increasingly entrenched market power across a range of critical markets. And while this position was partly driven by kind of inherent economic factors, economies of scale and scope, network effects, etc., and also strategic anti-competitive behavior, it was also clear that the party's very substantial M&A activity had played a role in the position that they'd got to. And to give you a flavor, I recently worked out that since 2000, the top 5 companies, the GAFAM, I think they keep changing their name, so they're now the MAMA. But anyway, the MAMA had accounted for 774 mergers and acquisitions. So that's an average of 7 per year per company, which is actually quite a lot. Now, many of those are pretty small, probably not very consequential for competition, but at least some of them, at least looked at with hindsight, had very clear, fairly clear anti-competitive effects and help bring us to where we are. What we certainly can say is they weren't given enough review by the merger regimes anywhere in the world. And with the Facebook Giphy merger is the first ever outright block of a merger involving any of those top 5. That's a recent CMA decision, which is currently on appeal to the CAT. So I won't say anything about it other than that. So in 2019, I was part of the Furman Review, which is a UK government commissioned expert report to consider these competition issues in digital platforms. And it's well known that we recommended that there be ex-ante regulation and some changes to the merger test actually for these biggest digital platforms. But it's actually not as well known that we strongly recommended a new revision to the UK merger assessment guidelines. And we were quite specific. There's a kind of big list in there of what we wanted the CMA to consider in doing those revisions. Our intention wasn't that the assessment guidelines should be specifically redesigned for digital markets. It was more that we thought digital markets had raised the profile and importance of certain issues that were of general relevance across markets and therefore merited further guidance, but for both digital and non-digital firms. So the CMA acted really quickly, and the revised merger assessment guidelines came out last year. And I thought I'd just run through really quickly, and I know I'm taking more than my due time, the biggest changes, but just very much in headline terms. So first of all, there was a further downgrading of market definition, which is now discussed in the final chapter of the guidelines, which is notable in itself and is described as a useful tool, but not an end in itself. The key focus is on the impact of the merger on rivalry and the competitive constraints on such rivalry. A second point in the guidelines is they really have a much stronger focus on assessing potential, the impact of a merger on potential and nascent competition. A third point is that there's a much greater emphasis on innovation as a theory of harm. A fourth point is there's a lot more in there about how you assess multi-sided platform markets in digital and not in digital. These aren't just in digital. A fifth point is that there can be, there's more in there about the relevance of transaction value. You know, this was inspired by Facebook, Instagram, Instagram was a tiny company. It's completely understandable why the OFT let the merger through, but they never really investigated why Facebook was paying so much for Instagram. And it's now thought that had they investigated that more, they at least may have questioned the deal more. So the need to look at transaction value and more generally more focus on the internal documents relating to the deal and the deal valuation. And then finally, a removal of the presumption that non-horizontal mergers would typically be benign, which had been in the previous guidelines. And that was because a lot of the mergers that the big tech companies were actually engaging in were non-horizontal, and they could say, well, non-horizontal mergers, there's this presumption that they're benign, so, you know, what are you getting worked up about? And we felt that therefore, even though obviously a lot of non-horizontal mergers are benign, it was wrong to have quite such a strong presumption in there. And I just finished by saying, apart from the point about transaction value, which I don't think is in the list of questions that the DOJ and FTC are asking for views on, actually all of the issues that we changed in the UK merger assessment guidelines have been raised in the context of the US merger guidelines review. So I know there are other factors driving those, but in fact, if you look at the list of questions, they're pretty good questions, I think. But I would personally argue that the 2021 UK guidelines are a great place to start in thinking about some of the issues.
Yeah, thank you. But Elias, can you pick up the ball here a little bit?
Yeah.
On the face of it, a test which involves a significant impediment of effective competition would be where, well, Amelia might be going or wanting to go, rather than a sort of mechanical creation of a dominant position as was the old merger regs. But has that worked properly, do you think?
Yeah, so I think I would pick up on some of the points that have been raised by Carl and Amelia. I think the first one is this awareness that there is a problem about concentration and increased profitability levels. And I think that's the reaction or the phenomenon to which the neo-Prandasians are reacting in the US. And I think there has been for a long time the perception, at least in the EU, that we don't face the same problem. So there have been studies by Philippon, for instance, who argued this is mostly a US problem and less, or to a lesser extent, an EU problem, mainly also thanks to the forceful enforcement of competition law by the European Commission. But at least from what you can see in the literature, there's now more recent research, for instance, by Beigar and the OECD, but also Coltai, Lawrence, and Valetti, which shows that raising levels of industry concentration and profitability are also a phenomenon that is happening in the EU, albeit to a lesser extent than in the US. And I think a second important point that also Tom has just raised is that there has been recently quite a perception in the EU that the Commission is over-enforcing under the new SIC test, the merger rules. And this perception at least is present in the legal literature and amongst legal commentators, but it does not necessarily match up with empirical evidence. So there has been empirical evidence that the European Commission's enforcement activity actually reduced. And if you look at the merger statistics of the European Commission, you see that only 8 to 9% of all notified mergers are actually challenged by the European Commission. So this is less than 1 out of 10. And since 1990, so since the introduction of merger rules in the EU, only 31 mergers have been prohibited. So that's a very tiny fraction. And I think that's something interesting and an interesting background against which we can ask ourselves, so should this also be a reason for the European Commission to think about the revision of its merger guidelines? And what is also interesting, and I think that's the second point that I'd like to pick up on, is that you see revisions proposed in the US, you see also the revisions that have been taken place in the UK last year. And one question is, so why is the European Commission actually lagging behind those two jurisdictions? And because the European horizontal merger guidelines date from 2004, so they are older than the guidelines that are now reviewed or revised in the US and have been revised in the UK. And I think the major reason for this is that European merger control currently faces important uncertainty. And this uncertainty stems from two main factors. So first of all, Emilia already mentioned that the European Commission has been fundamentally challenged by the EU General Court in the CK Telecoms case. And this case fundamentally questions how the European Commission analyzes, in particular, unilateral effects. And the review of unilateral effects has been an important innovation also of the EU 2004 guidelines, and I think this has been fundamentally challenged now. A second challenge comes from the EU member states that are openly questioning the competence of or the exclusive competence of the European Commission to review mergers. So we had a number of mergers such as Siemens Alstom or Tata Steel ThyssenKrupp, where member states such as Germany and France argued the Commission should clear those mergers in order to create European champions. And the Commission then resisted to this political pressure and blocked the mergers. And now Germany and France came up with the proposal to actually give member states a veto power to overrule under certain circumstances the European Commission in merger control. And I think that's a second factor that is an important source of uncertainty for the European Commission. And the third one is really this growing concern about startup acquisitions and how we deal with innovation effects. Here, I think the Commission made important progress also by drawing on the work by Carl Shapiro, for instance, by analyzing the impact of mergers on innovation in Dow and DuPont or Bayer Monsanto. But when it comes to startup acquisitions, the European Commission is struggling to come up with effective tools now.
Yeah, well, thanks. That's very interesting. I want to go back.
Tom, can I?
I was going to go back
for a
to
moment. Yeah, I just particularly what Amelia was saying about what you did in last year with the merger assessment guidelines. I'd like to link that to what we did in the US in 2010 when I was there, and what is likely to happen now with the current review. First, I think what you all did in the merger assessment guidelines last year was really brilliant, particularly on innovation and on potential competition issues, two of the big issues, sort of dynamic issues about how do we make competition work, not just static, but over time. And I've been writing about that and pushing that for a long time. And so it was really just very nicely way of taking I think the correct economics and distilling it into guidelines, just really very nicely done. We'll see. I think there's going to be some interest in doing that in the US too, to follow that. And we laid foundation for that in 2010. We added a whole section on innovation, which hadn't been in there before. And we said some things about this, although we didn't go as far as, now I would look back and say, I wish we'd gone a bit further. The other thing, though, that you did in the UK that will not happen in the US, and this is another whole front that's going to be fascinating to see over the next year, is as you said, I think, significant downplaying of market definition. When I read your merger assessment guidelines, I'm like, wait, where is market definition? Where's market shares? And it's tucked at the back. It's like I said, at the very end, it's like, oh, by the way, it's something we might look at if we feel like it could be useful. We don't need to do it, by the way, and we might if it's helpful. It's just a completely different thing than the US. And for good reason, because our case law is so heavily based on the structural presumption, basically adding up market shares and seeing if the concentration goes up. So what I think is going to be fascinating with this next round is we also downplayed the market definition to some degree in 2010, but we have stuck with it very strongly because it's so important. That's how the government wins cases in the United States, is by getting their prima facie case of increasing concentration caused by the merger. But if you look at the neo-Brandeisians are very much about a structural approach, and they're very skeptical, even hostile about trying to figure out the economic effects of a merger. They think that that's been trying to do that is hard. The defense is always going to have a counter story, and you bear the burden of proof, so the government's going to lose, and it's basically a failure. So they really don't want to talk about economic effects. And I've got some rather striking quote by Lena Kahn to this effect in her writing. And so in that sense, they might want to really emphasize structure and market definition, sorry, market structure, market shares. So go in the complete opposite direction of what you did in the UK. Now, I think that's going to be problematic if they do it for various reasons, but it would create quite a gap between the US and the UK at least, and probably the EU as well, if they do that. And they might, I don't know, but they might. They kind of want to. It's structural is how they think about things, very structural. So there's a real difference there that's brewing.
Yeah, can I come on the structural side? I mean, you can use structural presumptions if you've done a market definition, obviously, in kind of two ways. You can have rebuttable presumptions of us that there is a problem, so there is an SLC, a substantial lessening of competition, or you can have rebuttable presumptions of no SLC. And in fact, the US guidelines, at least currently, claim to do both. So they, post-merger Herfindahl's are below 1500, and then the market's just unconcentrated, no problem. And actually, that is something that's now slightly missing from the UK merger guidelines, you could say, is there's not that much to kind of say, just don't worry, this merger just isn't a problem. And we did have a bit more of that in the 2010 guidance, but I think it is inherent in a way in the direction that we've moved, the reducing the reliance placed on market definition. And what we've put in instead is a whole set of factors that mean that your merger is more likely to raise problems or less likely to raise problems. So we have kept with the economics, but then we've tried to put the economics into a set of simple things that you could look at in your market to decide, rather than just defining your market and getting market and calculating shares. That said, interestingly, what you've said, and this is where I probably do get a bit neo-Brandeisian, it actually links to the one thing that the CMA didn't do relative to what we recommended in the Furman report, which is we were concerned that in the old EU dominance test, it was basically said a merger would be blocked if it created or enhanced a dominant position. So what you would do is you'd define your market, you'd see, have you got a dominant position? And then if the merger enhanced or it created it, then pretty much it was a problem. And we thought that actually, had you applied that test to some of the mergers that the big tech firms had done, you might have been more likely to find a problem than applying the more economics-based SIEC test. And therefore, we actually thought in Europe, actually, arguably, the new SIEC test kind of incorporates both, because it says SIEC, which can be generated by an enhancement or a strengthening of a dominant position. And I thought that was quite nice. Not that the EU is actually applying that, but it's quite nice. We wanted the UK to go a bit more that direction. Unfortunately, because we were pulling back on market definition, I assume that, I actually don't know that, but I assume because that wasn't introduced. But I actually still think there is something with these firms that are kind of really easy to see their dominance. Actually, that is the right test to be applied.
Well, there's a US version of this that you're going to hear about if you haven't yet. Our statute, this is the Clayton Act, Section 7, a merger is illegal if it may substantially lessen competition, or, and this is the other part, tend to create a monopoly. Now, we've all, I have to confess, focused on the first clause and not so much on the second clause. But both agencies now, that is both Lena Khan at the FTC and Jonathan Kanter, head of the Antitrust Division at the Department of Justice, have explicitly pointed out the may tend to create a monopoly clause. And so that could be a firm that's quite strong, getting some additional assets or skills and getting more efficient might create a monopoly. So I wouldn't think of that as lessening competition because they're getting, let's say, more efficient, but it's not out of the question. It's not a crazy interpretation of the statute either. So, and they are really talking about what to do with that clause as they revise the merger guidelines.
That's really interesting. Yes.
Can I just also step in on this question about presumption? Because if I understand at least your writings, Carl, more recent writings also in response to this consultation on the revised guidelines correctly, I think you, even though you're, I think, skeptical about the structural impetus of neo-Brandasians, you're nonetheless arguing for a strengthening of the structural presumptions, if I'm not mistaken. And I'm just wondering to what extent you think this should be also transposed to the EU, because currently the case law by the European courts actually suggests that there's no such thing as a presumption. And the second question is to what extent this structural presumption actually ties in with your work on the assessment of unilateral effects and the insight from economic theory that market structure is not necessarily a good, or market shares are not necessarily a good proxy for substitution and the likelihood of unilateral effects. And so are there alternatives to a purely structural presumption that might help us in strengthening the enforcement of merger policy?
Well, Counselor, you've got a very good line of questioning, but fortunately for me, I'm prepared and I'm used to being cross-examined, so I'm ready for this. So I've been writing for years about strengthening the structural presumption in the United States. I have a paper with Herb Hovenkamp on this a few years ago. And the reason for that is very practical. I've been writing for 25 years, we need stronger merger enforcement. The way the government wins the United States, given our case law, is by showing that there's a significant increase in concentration in a relevant market. They also have to tell the story about harms that will result from the merger, economic effects, but the way the government wins as a practical matter in litigation is through the structural presumption or establishing the prima facie case based on concentration. So that's just, now I don't know that I would pick that regime, but I don't pick the regime. This is settled case law going back at least to the Supreme Court's decision in Philadelphia National Bank in the early 1960s. So given that, I'm working with the reality and with the case law to strengthen that, the government's hand in those cases. Now, the second part, what about upward pricing pressure, unilateral effects? And, Amelia, I want to say it was tremendously helpful when we did this in 2010 at the DOJ and the FTC, that you and Allison and the OFT and this Competition Commission were doing this, and you were ahead of us. I remember, I think it was Allison came and testified at one of our hearings. We were gathering information, and all these merging companies were very concerned because, think about it, unilateral effects. You say, look, if the merging companies are substantial direct competitors, I'm pretty much worried about it. That's all I need to know. I don't need to define no stinking market. I don't need to know this and that. That's enough, right? And we got this measure, and they were very scared of this, particularly in sectors with high margins, like computer software or something, or pharmaceuticals, okay, where it's going to work against them for good reasons, okay? So they were fighting back and saying, terrible thing, you can't do this. Market definition is the only way to go, because they knew how to play that game. And it's crazy thing, it'll never work. And so Allison shows up, and Amelia, I know you were part of this too. And she says, oh, well, in the delightful British accent, of course, well, we're doing it and it's working just fine. So this made it very much more difficult for the emerging parties lawyers, essentially the defense bar, to say this was crazy. So look, the economics of this has developed greatly in the last 25 years. There's been tremendous amount of work theory, econometric work, merger simulation, demand estimation. Indeed, a lot of industrial organization economists have worked on these very issues about how do you understand how pricing competition with differentiated products works, estimating those models, and then how does it change if something changes, a cost, a merger. I mean, that's been an enormous amount of work. And both in the UK and in the US, we've put that into the guidelines now. So and I have a recent paper with Nancy Rose where we have suggestions for what to do with the merger guidelines in the US. And that's one of the things is, I'm really pushing for, I would be happy if we had a presumption here that if you had basically a high upward pricing pressure index, that there would be a presumption against the merger. Now, we didn't do that in 2010 because it was a new tool. People were like, what are you doing? We put it in there. We explained that it was the better way to evaluate unilateral effects than Herfindahl's, which is not a good match. But you can only go so far. Now they can go farther now, but they can only go so far too, because the case law is actually developed much more favorably, contrary to your telecom case there, much more favorably to unilateral effects in the United States. But it's still the case that the government, that's more like the government says, oh, we see an increase in concentration. And by the way, here's our way of indicating we think there's really going to be harm. It's not how they win the case. And certainly saying they get some sort of presumption, the emerging parties lawyers and probably the courts would say, I don't see that in the case law. You can't create presumptions for yourself. Very nice try, plaintiff, government. So you can only go so far. I mean, it's the same thing. You want to move the courts along, but you can't just tell them, oh, you should change everything you're doing. And this is a risk factor because the current leaders, talk a very big game. But if they go too far in the merger guidelines, then I'm concerned that we'll lose the extraordinary status of the guidelines of the United States, which is, think about it, a government agency that's suing big companies and going to court. And the courts have typically said, okay, we will accept the government's formulation about how to do the analysis, even though they happen to be just one party in front of us. And in fact, the merging parties have historically said, we will accept it too. And if you use it properly, we win. Well, if they go too far and they're detached from the case law, I don't see why that's going to happen. It seems to me merging parties will say, government says they should do it this way. They've dramatically changed things. That's not the case law. Maybe that's wishful thinking, but they should go to Congress if they want that. So you can only go so far. And I've been frankly trying to thread that needle in providing helpful economic input to move things in the right direction with the recognizing the reality of the judiciary.
Well, can I just put that back to you? Your recent paper pointed out that if we adopted Herfindahl's as a tool of analysis, that the administration had essentially massively under-enforced the existing guidelines. Now, how is that going to change, if it's going to change at all? Or is it based upon an understanding that the courts are just going to throw things out?
Well, let me just, for everybody to understand what Tom's referring to, this is my paper with Nancy Rose,
Yes.
but actually referring to a paper about a year ago with Howard Shalansky, where we looked at all the mergers that were litigated between 2000 and 2020 or 21. So 10 years before and 10 years after our guidelines revision of 2010. And we found that actually in both the 10 years before and 10 years after, the typical average, let's say, Herfindahl of a challenged merger in the market the government defined, to be clear, was like 6,000 post-merger Herfindahl with a 2,000 increase or something. I don't have the numbers exactly right, but it was huge. And so that's what I think you're referring to, Tom.
Yeah, it is.
So look, I should say in 2010, the idea, we did raise the Herfindahl in levels, which people criticize us for now. It was a very different environment. We were really saying, Christine Varney and John Leibowitz, who were the leaders of the agencies, this was the idea was, look, we are going to raise the stated levels and try to actually enforce at those levels, okay, rather than the enforcement levels are way higher again in the previous 10 years, like 6,000 Herfindahl's and 5,000 Herfindahl. So that was the idea, so that we would have transparency. We would be telling the business community and the world accurately what we're trying to do. And the 1,500 levels wasn't happening, okay? And you just almost never was that happening. There's a few cases with the oil industry or something, okay? But so we didn't, that was not successful, okay? Because the enforcement did not go down to that level. So I would still rather see enforcement at the stated levels now, or lower if you want to try. But I would rather have accuracy rather than, oh, we claim we're going to enforce at this level, but we don't do it. That's just, seems to be a hard nut to crack. And the other thing on this, Tom, is all of this depends on how do you define the market, okay? And I'm also concerned if a very structural approach, a part of my paper with Nancy is we say the hypothetical monopolist test, the technical method used to define markets, at least with the economics associated with that, can lead to very narrow markets. I think that's a tool the government can use. They have to convince the court that's reasonable, so they have to do something that's going to work in court. But if they throw that out as too much economic gobbledygook, then I'm concerned they'll just end up with much broader markets, which is more how things were in the 60s, actually.
Yeah.
And that could be counterproductive in terms of enforcement.
Thank you. Yes. Celia, you're nodding. I mean, what's your take on that in the UK setting?
So, I mean, I think we've managed to be, because we have such a different setup in the UK. So obviously the CMA is the decision maker. It can be appealed on JR grounds, but as long as it more or less, well, as long as it is robust and considers all the evidence and applies the evidence in and analyzes it in an appropriate way, then it makes the decision. It doesn't have to persuade a judge about the rightness of its decision. It has to persuade a judge that it has followed its own guidelines and thought about it properly itself. So that's actually quite a different situation. And I think it allows the UK to stay more at the frontier of actually how to analyze things correctly, to stay more economic, and broadly to get better answers. And that means kind of actually not blocking mergers that are perfectly fine and blocking mergers that are not fine, but you wouldn't necessarily catch under a structural presumption. So I think it is unique to the well, it's very different to the US environment, and allows us therefore to dispense with the market definition and to some extent with the structural presumptions without becoming very non-interventionist. In fact, the UK is currently seen as relatively interventionist. So I think that the UK is in a good place, but it starts from a very different place to the US. I would just mention, because Carl was talking about the kind of before and after guidelines work. On the point I was making earlier, I just wanted to mention some really interesting work by someone called Pauline Affelt, who looks at the EU merger interventions before and after the move to the SIEC test. So this is the thing that allows you better to look at unilateral effects mergers. And what she finds is that after the move to that test, the EU does intervene substantially more against firms with less than 40% market share, which is what you would expect. But she also finds there's a very substantial reduction in merger intervention against firms with more than 40% market share, which I think goes to that point that actually, I mean, 40% doesn't equate obviously at all to dominance, but there is much less focus on the enhancing and creation of a dominant position. The more structural presumption idea with the move towards looking more at unilateral effects. She doesn't form a value judgment whether that's good or bad. I personally am worried about it.
Let me ask a question. Let me out of role, which is, and Elias, you brought this up. There is this view that and it's a neo-Brandeisian view, not just them, that the US, we've had this failed policy, increase in concentration monopoly, was the EU has done much better. Okay. This is certainly Philippon's book. He has that as important. Okay. And I'm skeptical of that argument in various ways, but what is striking to me is my observations over at least 20 years now would be there was a convergence in merger enforcement, I would say, between the two jurisdictions, let's say the US and the EU, particularly when the UK was still part of the EU, let's say, so we don't need to split you off for this purpose. And so the notion that somehow the US was really lax, the EU was really tight, and that's made all the difference, it strikes me as odd. Do you think there's been a significant difference? I mean, in enforcement level, I haven't seen that, but what are you seeing?
So I just want to also point to one of the recent studies that compare the US and the EU by Bergman, who did a number of those studies, and he also finds that there has been after the reform a convergence. So a decrease in especially the challenges of dominance, but a more robust approach towards unilateral effects. And I think that's very much what you also suggest. But I think that in broader terms, there is some evidence also by other studies that merger enforcement in the EU has to some extent declined. And I'm also quite puzzled by this account by Philippon, for instance, that the US was always much more relaxed than the EU in merger control, or in general about in competition enforcement, whereas the EU has been very strong. And I think this might be true for the enforcement of Article 102, so the enforcement of competition law against dominant firms or monopoly powers, or Section 2 of the Sherman Act, but not necessarily the case for merger control, at least what we see in the recent years. But at the same time, I think what is really puzzling as well is that with the adoption of the SIC test and the focus of the European Commission on unilateral effects, there has been actually the growing view amongst legal commentators that the European Commission is exerting too much discretion and is over-enforcing. And I think one of the reasons for this is that the European Commission is increasingly using quantitative analysis. And for instance, the General Court in CK Telecoms actually gives credit to the argument or the criticism against the gross upward pricing pressure index that it would always yield positive results and therefore lead to the challenge of any horizontal merger. And I also wanted to perhaps raise this point. So to what extent do you think this criticism is valid, and to what extent the European Commission should, for instance, use an efficiency credit that has been also supported by the General Court in the CK Telecoms judgment, or to what extent do you think that's not necessarily the right idea?
I think this criticism is completely bogus, but it seems to get people's attention. Here's why it's bogus. Look, if you have any quantitative measure, and let's talk about two of them, Herfindahl index or upward pricing pressure. Any quantitative measure, it's continuous variable. It could be 0. It could be, some high number depending on the scale. It's true in any horizontal merger, the Herfindahl is going to go up. But people don't say, oh, what a terrible thing. You can't use that because any merger will cause the Herfindahl to go up. So it's unacceptable. It's a crazy thing to use. No, what they say is, we understand if it goes up a very small amount, you don't make much of it. In the US, we legally, as a matter of settled case law, there's a sliding scale. The more the Herfindahl goes up, the more the concern is, the stronger is the case that the government has based on this structural presumption. So we understand it's not that complicated an idea. Okay, you've got to measure. Now let's apply it to UPP, upward pricing pressure, or GUPPI, gross upward pricing pressure index. Same idea, just different names. again, it's true. Any merger between two companies that compete directly against each other, there will be some upward pricing pressure. But you don't say, oh, therefore it's unusable. You say, well, I should have some notion that if it's very small, then I'm not going to be worried, just like the Herfindahl. Okay. Now, I will say there was a debate about that in 2010. What do we do? Essentially the equivalent of a safe harbor, a low Herfindahl index, what would be a low value? So I think it's a very fair point, not bogus at all, to say, tell me what level of upward pricing pressure is going to be low enough that I shouldn't worry, or high enough that you're really worried. Tell me what you're doing with this index. And the thing that's really good about it is we can do that. Okay, we can do that much more effectively than we can with the Herfindahl, where we don't really have we'd like to believe we have really good empirical evidence on mergers that create a Herfindahl index increase of 200 versus 500. It's not very good evidence. We don't really have it there. We tried for decades. People were trying very hard during the middle and second half of the 20th century, the structure, conduct, performance paradigm in IO, and it didn't work very well. I'm not saying we should throw that out. It's just we don't have a good scale that says it should really be 1,500. It should really be 1,800. We don't have that. We have it much more actually for upward pricing pressure, because we know just how much of an efficiency the firms would have to achieve in cost to offset the pressure. So again, we don't have great empirical evidence about the effects of mergers. This is a major problem for the whole area. Okay, that's just a shortcoming of this field of economic science. We don't have as much evidence as we'd like, but we do, at least in theory, understand the relationship between this upward pricing pressure and the efficiencies that would offset it. And we can go into that more, but that's very doable. There's a bunch of papers about it. I've written about that for decades. So, and I wrote an article while I was still at the DOJ in 2010 or 11, suggesting upward pricing pressure of less than about 5% would be less likely to be a concern, with some caveats, but the agencies were never willing to put forward sort of a safe harbor, if you will, or a number that would be low enough you wouldn't worry. And I don't think they should do that in an absolute sense, because there are some complications, but I think some guidance would be useful. And so this claim that it's always positive, so you can't use this metric, is bogus. I'll come back to that.
Interesting.
I just mentioned that there's a big debate on exactly what levels are appropriate in the UK Asda Sainsbury merger, which was in the end blocked, where they diverged from the 5% in the end, but they explained very clearly why.
Yeah, and look, I think it's a great debate. And I don't know. Look, Joe and Farrell and I wrote this in our paper, 12 years ago or something. Maybe it's not 5%. Maybe it's 2%. Maybe it's 8%. I mean, I don't care so much about that. I mean, you work it through. The point is, this is a much better tool for evaluating unilateral price effects than Herfindahl changes or levels, Herfindahl levels especially. It's a very nice work by Volker Noke and Mike Winston on this recently. And then we should have that discussion about what we make of different levels in different contexts, along the lines of what your merger assessment guidelines do, which is, here's different factors you consider. I don't like these things about, oh, it's 3% and that's it. But it's like, it depends on the other evidence. It's one piece of evidence, that's the thing. And so it just needs to be put in the mix. But to claim that, oh, it's always positive, so you should throw this number out, that's just dumb. You're throwing out valuable information. Don't do it.
I actually think that is actually a really important other aspect of, in particular, the most recent revision to the guidance, which fits exactly with what you've just said, which is it really, in the UK, the new mergers guidelines are very much about triangulating all the evidence and not saying there's ever any one killer piece of evidence. They're very clear that quantitative is not necessarily better than qualitative, and that the agencies have a degree of discretion in which bits of evidence that they consider, but it's all about, overall testing a theory of harm and judging whether you've reached the required level of sureness that there is going to be, that there's an issue.
And look, I will say, with a lot of experience in the government, studying mergers as an expert witness in courts, it's all about, it's the whole, you look at the whole set of evidence, and, and my concern, look, maybe the DOJ and FTC will go in that direction now, But a very structural approach is quite the opposite of that. I wrote about this in my fox versus hedgehog paper about, at that time, about shifting from one big thing, the Herfindahl index, to a lot of things that you look at. The problem, my concern here is that, again, I'm trying to participate in this process and nudge them in what I think is the right direction, is everything that you just said, Amelia, and your guidelines are all about, look, here's all sorts of stuff we're doing to try to figure out what are the economic effects likely to be. Okay, there's evidence from the merging parties documents. There's entry evidence. There's evidence, was there collusion or attempts at collusion? There's diversion ratios. There's bidding events. All this stuff is there. There's innovation. There's okay. But let me read you something from Lena Kahn that makes me worried. Okay, Herb Hovenkamp and I wrote in our paper arguing for stricter merger enforcement and strengthening the structural presumption. We wrote, quote, "Market structure has been a means of tackling merger law's more fundamental concerns, which are higher prices or reduced output or other consumer harms that result from less competitive market structures." I thought this was a very safe thing to say. Those are the harms we're worried about. Market structure is not an in and of itself. It's a signal about bad effects. No, says Lena Kahn. She writes, she criticizes this, says no, quote, "But this imports into structural analysis a focus on outcomes, misreading its purpose and orientation and potentially exposing it to weaker enforcement." So her view, at least as of a year or two before she became chair of the FTC, I think she was out of law school, but just out of law school, was no, structural, it's the structure itself that you care about, not the outcomes. Now, maybe she's changed her view, or maybe she won't have enough of a vote to get there. But if that's the view that prevails, we'll be in a very different place.
But the holistic approach, which I think I'm hearing here, where one stands on an issue sometimes depends where you sit. And I sit as an advisor to companies, and by and large, they're looking for an answer, not a research program in anticipation of a merger. And you probably have had the same experience, that 9 out of 10 mergers don't go ahead because somebody says it doesn't pass the straight face test, it won't work. It's pretty high. Now, if we inject into future analysis a richer, holistic, more detailed taxonomy, it's going to be very difficult for people like me to give advice. Maybe that's right, and who's crying about that? But can you see my point? The whole business of assessment ex ante will be very difficult.
I think that's a little bit of a false dichotomy, though, because in fact, what happens is there's always huge amount of uncertainty, particularly in differentiated goods markets, about what the market definition is going to be anyway. And as Carl said, the correct market definition is often a lot narrower than the parties would ever think, and that you as a lawyer would be able to advise them without actually doing the analysis. In which case, if you apply a structural presumption, you're probably going to misguide them anyway. So actually, I would propose that if you've actually got a good nose, you can usually sniff if there's a problem. A lot of these mergers where people say, I need to give clearer guidance, you can give clear guidance. You've got a good enough experience and nose. Where there is a real risk, actually asking some of the questions that we put in the guidance, I think is the right way to go, whether you're actually going down the US route or the UK route, closeness of competition, things like that, the size of customers, types of customers, that all really matters wherever you are. In the UK, we do it a slightly different way, but actually the questions we're asking are just the same, I think.
Okay.
So Tom, I want to both agree with Amelia, but say, look, we've already been doing that a lot in the US for at least 10 years since the 2010 guidelines, and arguably for 25 years. And I've been involved in, over the years, not so much recently, with advising potentially merging parties and merging parties, as well as testifying for the government with some regularity. And it's not that, it's doable. You know, you look at things and you give advice. I mean, look, the investment bankers are charging way more than the antitrust consultants. So, you know, there's some work involved. Okay. So I just, yes. And look, most mergers, it's just not that much of an issue. Either not horizontal, so we don't have the same issue, or they're, you know, obviously bad or whatever. It's a relatively small number that are in this gray zone. But I will say, this is where I think the neo-Brydesians want to go, which is, and they would say, it's not just the advisors are having trouble, the courts. They're like, what are the courts going to do? You tell all these stories. So they think that's working against merger enforcement, because the courts the defense will put on some story, right, and counter all these things, and the government has the burden of proof and they'll lose. Now, my answer to that is rebuttable presumptions and having the courts, you know, get with it in terms of unilateral effects, you know, which is very much what your general court did not do in your TCK Telecoms case. But that's you know, that's a hope on my part. While the neo-Brydesians are hoping that they can somehow convince the courts that modest increases in market shares are enough to establish a presumption against the deal. I don't see that happening. That would be quite a shift for the courts. But either way, we have to deal with the judiciary, and it's hard.
Okay. May I just take you back to something we talked a little bit about near the beginning, and that's how we handle potential competition. And here there are no easy issues about market share because they're not competing with each other. But on the other hand, there have been, as Amelia said, one or two really rather good examples where large companies have diversified, presumably because they want to be in an industry, they're buying talent and expertise, intellectual property rights, but also, I guess, sometimes because they're rather fearful that the new technology might supplant some of their own. Now, how do we begin to analyze that and to offer advisors an element of certainty, or at least a taxonomy, and how to approach that?
Well, I talk about that a fair bit in my paper with Nancy Rose. That's up on my website. All my papers are on my website at UC Berkeley. That got published in the Antitrust magazine recently. But I think the basic idea, again, as an economist, is if there's evidence that the target company, let's say I'm an acquiring company, I have quite a strong position. I'm not saying it's dominant, but I've got a good solid position. I'm making good profits. I would like to protect those, presumably, and continue those into the future. If the company I'm buying, I would say something like, now don't hold me to these exact words, but sort of has a reasonable prospect of entering and competing against me in the foreseeable future, then that raises concerns, at least, let's put it that way, particularly if the acquiring company is dominant, has a, you know, call it a dominant position in Europe, or maybe monopoly power in the United States. I would even go with then that should be a presumption against such a merger. Okay, and that basically the company would have to explain itself. Again, reasonable probability of entry in the foreseeable future. And by the way, just for consistency, to be clear, I would say the same thing if a dominant firm buys a competitor with a 1 or 2% market share. Like, you know, I'm not keen on that. That little firm might grow or might not grow. I don't know. And there's a lot of uncertainty. So it's partly is lowering the burden of proving something with a likelihood, or a high likelihood, or the balance of the probabilities, as you refer to it in the UK. I think that is too high a hurdle. And the other hurdle that's been too high in the US courts, at least, is requiring the government in such cases to show something like this was likely an imminent entry. Okay, imminent and, you know, very likely, as opposed to, you know, it could happen, and that's enough to be worried about it. So those are challenges. So that's the way to handle it. But with, again, always in mergers, rebuttable, right?
Rebuttable presumption,
You might say, look, there's all these efficiencies, or they're going to do these great things, or the company's about to go under, you know, whatever. So you're telling the story.
Is the EU going to handle that, do you think, Alice?
So I think the EU is currently trying to find first ways to actually scrutinize those mergers, because I think one of the important concerns when it comes to the acquisitions of especially startups is to get them under the scrutiny through the jurisdictional thresholds. And I think the European Commission is currently trying to find two ways. So on the one hand, it put forward guidelines on Article 22, which allows member states actually to refer mergers that would otherwise fall through the cracks of the jurisdictional thresholds of the EU merger regulation to the Commission. And that has been actually applied recently in the Illumina Grail merger that has been also challenged by US authorities. And the Commission is currently waiting for the outcome of the General Court's ruling and on its use of this referral mechanism. And then I think a second mechanism that is currently discussed is the provision of Article 12 of the Digital Markets Act, which would also allow the European Commission to scrutinize startup acquisitions by gatekeeper platforms. And I was also wondering how the US, for instance, in the US setting, the authorities could actually scrutinize those mergers that are where the startups actually have a very a low turnover threshold. And I think Amelia already mentioned the focus more on transaction value as one of the proxies. Yeah. And I definitely would suggest that the European Commission would need to address this concern in greater detail in its merger guidelines. So currently there are two paragraphs that deal with potential competition, which are actually setting a very high standard, so paragraph 58 to 60. And I think the CMA has shown in its guidelines more recently that you can address this in a different manner. And I also think it is quite interesting that Carl, and also I think that's the way the CMA proposed it recently, namely the lowering of the standard of proof when it comes to those startup acquisitions. I think that's a very interesting proposition, but it also is likely to face major challenges in the EU because the General Court more recently suggested that sometimes in specific mergers, the standard of proof can even be stricter than the standard of the balance of probabilities. So this is rather going in the opposite direction. So I'm also wondering to what extent we could actually follow the UK approach and lower the standard of proof for specific mergers, for instance, acquisitions of potential competitors.
So I should just emphasize that the debate around lowering the standard of proof is only for the regulated big tech firms and is still under consideration by the UK government. So we have no idea if that will actually go through. But in the meantime, the guidelines do address this, and they do just give greater weight to the kind of potential competition issues. They and one of the things that they point out, of course, that you have to think about whether there would have been whether the acquired firm would have been entering or expanding in the market. And then you also have to think about, well, if they had, would that have been a more competitive outcome? And you assess, you still have to show an SLC relative to that counterfactual or to that potential factual. But what they do highlight, which has been a bit of a legal hang up before, is you don't have to judge exactly what's going to happen. You don't have to say exactly what product they would introduce or exactly how they would enter the market. You can have a whole set of different ways and things that they might do. And if you kind of, on the balance, overall, thinking about all of those different options, conclude that on the balance of probabilities, there is going to be an SLC, then that's absolutely fine. I would also say that this whole idea of kind of my push in the EU and here to slightly increase the focus on the creation and enhancement of a dominant position test again, that would also fit with what we're talking about here.
I would encourage particularly the academics who are watching today to do things to try to educate the courts, I'll put it that way, about how to understand probabilities, particularly, in dynamic and uncertain. We start to talk about innovation. Innovation is all about risk and uncertainty, whatever. And all too often, the courts are like, well, we're not sure what's going to happen in the future, so I guess the party that bears the burden of proving something about the future is going to lose. That's a very impoverished way to think about probability and prediction. We have one case, the activist case, which is a pay for delay pharmaceutical case at the Supreme Court, where the majority said if a branded pharmaceutical company pays a generic to delay entry, and the generic might have come in the future, depending on the outcome of, say, a patent infringement case, the mere probability of that entry is something that's worthy of protection under the antitrust laws. The risk of competition or the possibility of competition. And Justice Breyer wrote that opinion. It's a really good opinion. Mm-hmm. And I'm looking for ways for us to leverage that to other cases, that the prospect of competition is protected by antitrust law. But the courts don't go there easily. And frankly, I'm worried about our Supreme Court, whether they would even go there today, given the changing makeup. It was a split decision. But I think maybe you could make more progress on that in the UK and Europe, and that would be a big help for properly enforcing competition law in dynamic settings.
And of course, what you know already, I mean, the Furman Review itself did propose a new test, which would be generic to all mergers, which was to address exactly this, because actually what we realized is lots of economists, when they write papers about merger assessment, they assume that the merger goes through if the expected value of the merger is positive, and that it gets blocked if the expected value of the merger is negative. And economists, when they're doing an expected value, they add up all the potential outcomes and then the likelihoods of those outcomes, and you add up all those different possible outcomes and all those probabilities, and you get an overall expected value. And what we pointed out is that in practice, merger assessment is nothing like that. With the new guidance, we're trying to make it a little bit more like that. But we highlighted that actually, suppose you have a merger, which is very relevant to some of the big tech mergers, where you've got a kind of 90% chance that this merger is kind of okay, maybe a bit efficient, could be quite good, but a 10% chance, or let's say 25% chance that it's really terrible, that it is going to completely destroy the last residual chance of competition that we have. Then actually, in an expected value basis, you've got a 25% chance of absolutely terrible, a 75% chance of okay. In the expected value terms, that is a merger that you definitely ought to be blocking, but the balance of probabilities test as it stands doesn't necessarily allow you to. And therefore, we said that we proposed an alternative test that would essentially have done more of an expected value approach. Now, we were told by lawyers that this is just actually increasing the bar too much because it's much too difficult to do this, and even all you clever economists can't do it. We said, okay, fine, but we at least need to be able to address those issues where what you're really concerned about, and it's exactly what you just said, is taking out that last option of competition, even potential competition, even if it might not have happened. If it had happened, it would have been incredibly important. And I think we've moved some way there with the merger guidelines.
And look, most people, lawyers, courts, when you tell them, oh, I want to deal with probabilities, they're like, sounds scary. It's all these numbers. How are you going to do it? It's not practical. But look, we're not talking about what's the probability this company will enter or have a product. We don't know. Is it 5%, 20%? We're not going to know that. I mean, they're not going to know that. Nobody's going to know that. Point is, it's if you think it's significant. I mean, courts make these judgments all the time. Is this just a totally, extremely unlikely event, or is this, it could happen? It's real. It could happen if it's going to give a lot of value and competition. It should be protected. Our Microsoft case, the biggest Section 2 case, really probably over the last 20 years, I guess, until we get the ones coming with Google and Facebook, maybe. That case, the appeals court, said Microsoft had done these things that might have excluded a competitor who might have come in, a nation competitor, right, who might have come in and made a difference. And the government doesn't need to show it's likely. It doesn't need to show it would have happened. It was a prospect that, in fact, Microsoft was worried about, right? Just like Facebook was worried about Instagram. And that's sort of evidence like, well, if they were worried, maybe we should take that seriously. I just think we need more of that in this innovation space. It's going to take work to get there because the big companies don't like that. And the courts have not, well, I've given some examples where they've gone there, but in mergers, it's been harder for them to do that. And so that needs work. And maybe you're making progress there. It's a jury's still out here in the US, I would say.
Just to add on this, so I think the CMA, at least in the Facebook Giphy case, goes a bit along the lines that Carl mentioned with respect to the Actavis ruling, so saying that even uncertain competition is something that is worthwhile protecting because it spurs in the end innovation also by the incumbent. And I think that's something which is quite a bold move by the CMA, and the decision is currently also under appeal in the UK. And I think it's interesting to see how this will pan out after the competition appeal tribunal rules on this case.
Yeah. That does seem to me that in future much greater stress is going to be placed upon valuation, as Amelia pointed out, and also the internal reasoning and rationalization for mergers. That would, of course, set up an equal and opposite reaction to ensure that that record is absolutely innocent. That's insofar as they can. But what can you do about that? Nothing.
Well, the only thing you got going for you as an enforcer is at least large publicly traded companies do need to have a decision-making process. They do need to explain to their board why you're paying all this much money, what you're getting for it, what the strategic value is. And hopefully with fair counsel, such as yourself, Tom, they will not abuse the privilege and hide everything from the government.
I'm sure that's right, because it's a fool's thing to do. Well, look, folks, I think we've probably reached the stage. We've exceeded our internal budget of time. All that remains is for me to thank you. I did sort of forewarn you that it seems it's always a useful exercise in a discussion like this to just go to each of you and say, well, okay, we've heard a lot now, but what is it, the one thing that you would want us to take away, having listened to you? That's perhaps an unfair question, but one I think you're used to. Amelia.
It's a very unfair because I haven't really thought about it, but I think that actually finding a way one way or another that actually the US and the UK and the EU are reaching broadly the same conclusions despite their very different frameworks has to be the goal, because in fact the goal should be kind of getting the right answers. I think the US has lots of potential in its new review of its guidelines to actually do some really positive things like we have done in ours. I share Carl's concerns, particularly having listened to him, that not every change may be for the better.
LS.
I think one potential area of divergence that we touched upon is the analysis of unilateral effects, and I think it would be very important for the European Commission in due time to clarify where, and also for the EU courts. So the CK Telecoms judgment is currently under appeal in front of before the Court of Justice, to clarify where we are going to. And another important area I think that we all touched upon is the analysis of innovation effects and also the assessment of acquisitions of potential competitors. I think what we didn't discuss is efficiencies. And I think here it might be interesting perhaps to enhance our thinking about non-price efficiencies, to what extent, for instance, also sustainability gains or environmental gains could be cognizable as efficiencies. So that's at least what the UK merger assessment guidelines, the revised version, seem to suggest that this could be possible in some circumstances. And I think that's an interesting development that might also be interesting for the European policy space.
Thank you. And Carl.
Well, coming back to the US, we have a new administration, still quite new, with leaders who are talking a very big game, talking about dramatic change to reverse decades of abject failure of antitrust policy, including merger enforcement. Those of us who have been doing this for a while are raising our eyebrows of like, well, really? Like we have a number of suggestions for doing things more effectively. And what are you going to do? Are you going to do that? Or are you going to do something else very different? The rhetoric is to do something very different. This administration, in their cases, they have not yet really had time to see how things play out when they go to court and how it's going to work. So I would say it's going to be, could be quite some fireworks, both with the guidelines and ultimately litigated cases brought by the FTC and DOJ. So I would say make your popcorn and get ready to watch.
Well, that's a very happy note. Let me, on behalf of the Centre, thank all of you for massive, terrific contributions. Thank you again. I think we're finishing.
Okay.
Thank you.
Bye.
Bye.
Thank you.